and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by LiveLaw. I'm your host Ostika Das and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover the Supreme Court's latest judgment allowing sub-classification among scheduled castes, the electoral bonds case, Shia women's right to conduct prayers in Ibadat Khana, the Delhi coaching center deaths, and much more. So let's dive into the headlines. This week, a significant ruling from the Supreme Court has allowed for the creation of subcategories within scheduled castes to allocate separate quotas for more disadvantaged groups. A 7-judge bench in a 6:1 decision stated that while subclassification is permissible, it must be backed by evidence showing underrepresentation of the subcategory and all seats cannot be reserved for any one group. This ruling relates to Section 4(5) of the Punjab Scheduled Castes and Backward Classes Reservation and Services Act 2006, which allocated 50% of job vacancies reserved for scheduled castes to Balmikis and Mazhabi Sikhs. This provision was struck down in 2010 by the Punjab and Haryana court, which relied on the E.V. Chinnaya judgment. That judgment had maintained that scheduled castes form a homogeneous group that cannot be subdivided. However, the Supreme Court's current ruling highlights historical evidence showing that scheduled castes are not homogeneous and that subclassification does not violate the equality principle enshrined under Article 14 of the Constitution. The court emphasized that the state must provide clear data for such classifications and such decisions are subject to judicial review. The judgment also expressed the need to exclude the creamy layer among scheduled castes from reservation benefits, a concept which is currently applied only to other backward classes. Justice Bela Trivedi dissented, stating that only Parliament can change the list of scheduled castes under Article 341. In her separate judgment, Justice Trivedi ruled that state legislatures have neither executive nor legislative power to subclassify or subdivide or regroup the castes, races or tribes specified as the scheduled castes, and therefore, and I quote, under the guise of providing reservation for the weaker of the weakest castes, the state could not be permitted to make any variation in the notification, nor could it be permitted to indirectly tinker with such notification published under Article 341(1). In another important update this week, the Supreme Court dismissed petitions seeking a special investigation team to probe alleged quid pro quo arrangements between corporates and political parties through electoral bonds donations. The court stated that it is premature to order an SIT investigation overseen by a retired judge without first exhausting the usual criminal law procedures. It also rejected demands for authorities to recover donations received by political parties through electoral bonds and to reopen their tax assessments, noting that these fall under the jurisdiction of the Income Tax Act. The bench, comprising Chief Justice of India D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, emphasized that issuing such directions now would be deciding disputed facts prematurely. The court noted that the purchase of electoral bonds and donations to political parties were based on a law enacted by Parliament. The petitions were based on assumptions that a quid pro quo relationship existed and that certain officials of investigating agencies were involved, which required a roving inquiry. The court highlighted that individual grievances related to possible criminality should be pursued using available legal remedies. The court also noted that reopening tax assessments and making recovery from political parties would fall within specific statutory jurisdictions, and issuing directions at this stage would be inappropriate. Turning to Bihar, the Supreme Court has agreed to hear the state's appeal against the Patna High Court's decision that struck down the Bihar Reservation Amendment Acts. These acts had increased reservation for backward classes, scheduled tribes, scheduled castes, and extremely backward classes to 65% from 50% based on data from the 2023 caste survey. Last month, the High Court ruled that the amendments were unconstitutional, citing violations of Articles 14, 15, and 16 of the Constitution. The Supreme Court has previously established that reservations should not exceed 50% to balance equal opportunities with provisions for backward classes. Senior Advocate Shyam Devan, representing Bihar, requested a stay of the High Court's judgment, referencing a similar interim order by the Supreme Court regarding Chhattisgarh. Solicitor General Tushar Mehta also noted that interview processes for employment were ongoing under the law. However, the bench, comprising Chief Justice of India D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, declined to grant interim relief and has listed the matter for further hearing. This development is an ongoing one and we will be back with more updates on this. In a significant decision, the Supreme Court has dismissed the Enforcement Directorate's plea challenging the Jharkhand High Court's judgment granting bail to Jharkhand Chief Minister Hemant Soren. Soren, who was arrested in January this year, faces money laundering charges related to an alleged land scam and illegal mining case. The ED contends that around 8.5 acres of land involved constitutes proceeds of crime. However, the High Court granted bail in June, concluding that there was no direct or indirect evidence linking Soren to the crime. The Supreme Court, with Justices B.R. Gavai and Vikram Nath, upheld this decision, describing the High Court's judgment as very well reasoned. Additional Solicitor General S.V. Raju argued that the High Court had dismissed witness statements recorded under Section 50 of the PMLA, but the bench was not persuaded and ultimately dismissed the Enforcement Directorate's challenge to the High Court's order granting bail to Hemant Soren. The Supreme Court has granted bail to Trinamool Congress leader Anubrata Mondal in the CBI registered case related to the alleged India-Bangladesh border cattle smuggling scam. Mondal, the Birbhum district president of the ruling TMC, is accused of involvement in a multi-crore smuggling ring. The bench of Justices Bela M. Trivedi and Satish Chandra Sharma noted that the trial was unlikely to commence soon. Senior advocate Mukul Rohatgi, representing Mondal, argued that they had not yet received English translations of the documents, including the charge sheet, which are in Bengali and run into thousands of pages. Additional Solicitor General S.V. Raju opposed the bail, arguing that Mondal could influence the trial. However, the court, noting Mondal's prolonged incarceration since August 2022, granted bail with conditions, including surrendering his passport and cooperation with the trial proceedings. However, despite being granted relief by the top court, Mondal remains in jail due to his November 2022 arrest by the Enforcement Directorate, which is also investigating the matter. This week, the Supreme Court delivered a significant ruling regarding the enrollment fees collected by bar councils. The court declared that bar councils cannot collect fees beyond the amount specified under Section 24 of the Advocates Act 1961. According to the Act, the enrollment fee payable to the State Bar Council is Rs 600 for general category advocates and Rs 150 towards the Bar Council of India. For scheduled caste and scheduled tribe category advocates, the fees are Rs 100 and Rs 25 respectively. However, some states have been charging up to Rs 40,000. Various petitions challenging these exorbitant fees as being violation of a statutory limits were filed in the Supreme Court. A bench led by Chief Justice D.Y. Chandrachud with Justices J.B. Pardiwala and Manoj Mishra emphasized that the Parliament's stipulated fee amounts must be adhered to, and state bar councils or the Bar Council of India as delegates under the statute cannot modify these fiscal policies. The judgment pointed out that high fees create barriers for marginalized sections to pursue their profession. Importantly, the ruling will have a prospective effect, meaning that excess fees collected so far do not need to be refunded. However, bar councils can levy other charges for services provided to advocates, but these cannot be considered enrollment fees. The Supreme Court has declined to interfere with the renaming of Aurangabad and Osmanabad to Chhatrapati Sambhajinagar and Dharashiv respectively. This decision came after several petitions were filed against the Bombay High Court's order, which upheld the Maharashtra government's notifications regarding the name changes. However, a bench of Justices Rishikesh Roy and S.V.N. Bhati rejected the special leave petition filed against the High Court's order. The renaming, approved by the Union Ministry of Home Affairs last year, faced opposition on the grounds that it was politically motivated and fostered religious discord. Petitioners argued that the name changes were part of the campaign in Maharashtra to rename all cities with Muslim names. The Maharashtra government, however, countered that naming a city after a revered personality did not have a religious connotation. The High Court had previously ruled that the renaming notifications did not suffer from any illegality. The Supreme Court's refusal to interfere further affirms this stance, allowing the renaming to stand. The Supreme Court dismissed a petition by Asianet News Network, Asianet Savarna News, and journalist Vishweshwar Bhatt, who sought to quash a criminal defamation case filed by actor Divya Spandana. This case stems from a news broadcast in 2013 that allegedly linked Spandana to the IPL spot-fixing scandal. Despite the news channel's claim that they did not directly implicate her, the broadcast repeatedly showed her photos and videos. Chief Justice Chandrachud, leading the bench, also noted the continuous mention of the actress's images during the telecast and as such ruled that there was no case to quash the defamation proceedings. "You're taking the fourth defense to defamation, that's a matter for trial," Chief Justice Chandrachud told the petitioners while refusing to grant them relief. The Karnataka High Court had previously refused to quash the criminal defamation proceedings, a decision that the Supreme Court has now upheld. In a landmark judgment this week, the Telangana High Court affirmed the right of women from the Akbari sect of Shia Muslims to conduct religious activities in the Ibadat Khana in Darul Shifa, Hyderabad. The case originated from a long-standing dispute over women's access to the Ibadat Khana. The petitioners, Anjuman-e-Alawi Shia Akbari Registered Society, had repeatedly sought permission from the Telangana State Waqf Board for women to conduct religious activities but received no response, prompting them to approach the High Court. The court, led by Justice Nagesh Bhimapaka, referred to the Supreme Court's Sabarimala judgment, which upheld women's right to enter places of worship. The judgment emphasized that the Holy Quran does not prohibit women from entering prayer halls except during specific periods. The Waqf Board's previous permission for Shia women to enter prayer halls was also noted, highlighting the discriminatory nature of the Akbari sect's exclusion. Consequently, the High Court allowed the writ petition, affirming its interim order from 2023 that permitted women to conduct religious activities in the Ibadat Khana. The Delhi High Court this week criticized the Delhi government's freebie culture following the tragic deaths of 3 civil services aspirants in a flooded basement at Rao's IAS coaching center in Rajendra Nagar. The division bench, comprising Acting Chief Justice Manmohan and Justice Tushar Rao Gadela, was hearing a public interest litigation seeking a high-level committee to investigate the incident. The petitioner organization Kutumb highlighted similar incidents in Mukherjee Nagar and Vivek Vihar, pointing out that despite judicial directions, civic authorities had not taken adequate steps. They argued that the deaths could have been prevented with timely action. The MCT's counsel defended the authorities, stating that inspections were conducted with numerous institutes shut down or sealed. However, the court questioned the lack of infrastructure upgrades and criticized the government for not addressing the city's drainage issues amidst rapid urban development. The court noted that the government's preference for freebie culture left civic bodies bankrupt, unable to upgrade infrastructure or pay salaries. The court implemented the Delhi police, directing the concerned officers to present all relevant files at the next hearing. Additionally, Judicial Magistrate Vinod Kumar of Tis Hazari Courts denied bail to Manoj Kathoria, an SIV driver accused of causing the flooding, along with 4 co-owners of the basement. Kathoria was granted bail later in the week by the Sessions Court. This week, the Allahabad High Court delivered a significant ruling in the ongoing Krishna Janmabhoomi Shahi Idgah Mosque dispute in Mathura. The court dismissed the plea of the Shahi Idgah Masjid Committee, which was filed under Order 7 Rule 11 of the Civil Procedure Code, challenging the maintainability of 18 suits brought by Hindu worshippers and the deity. This dispute revolves around the Shahi Idgah Mosque, alleged to have been constructed by demolishing a temple at Lord Krishna's birthplace. A 1968 compromise agreement allowed both the mosque and the temple to coexist. However, this agreement's legitimacy is now contested by Hindu parties who claim it was fraudulent and seek the mosque's removal to assert their right to worship at the site. Last year, the Allahabad High Court took over all related cases from the Mathura court for further proceedings. Justice Mayank Kumar Jain, who reserved his judgment in June, has delivered this verdict this week. Pronouncing the decision in open court, the judge declared that the suits filed by the Hindu worshippers and the deity are not barred under the Limitation Act or the Places of Worship Act. This ruling confirms that all 18 suits are maintainable, allowing them to be heard on their merits. This week, the Kerala High Court has underscored the importance of freedom of expression for cartoonists, affirming that they are an integral part of the press and media. The court quashed the proceedings against the printer and publisher, editorial director, managing editor, editor and chief editor of Malayalam Manorama. They were charged under Section 2 of the Prevention of Insult to National Honour Act 1971 for allegedly insulting the national flag through a caricature. Published during the 70th Independence Day celebrations, the caricature depicted Mahatma Gandhi in the Indian flag with a black line outlining the top saffron portion. The complaint was lodged by a BJP Area Committee General Secretary. Malayalam Manorama defended the caricature, asserting that it was an artistic expression meant to celebrate Independence Day and had no intent to insult the national flag or Gandhi. Justice P.V. Krishna noted that for an action to be punishable under the Prevention of Insult to National Honour Act, it must meet the ordinary meaning of insult, which involves derogatory or demeaning remarks or actions intended to offend or humiliate. The court found that the caricature did not meet this criteria and was in fact a respectful and positive depiction of Independence Day celebrations. Consequently, the court allowed the petitions and quashed the proceedings against the petitioners, emphasizing the importance of protecting the freedom of speech and expression. This week, a Delhi court granted bail to activist Medha Patkar in a defamation case filed back in 2001 by Vinay Kumar Saxena, who is now Delhi's Lieutenant Governor. Additional Sessions Judge Vishal Singh of Saket Courts also suspended Patkar's 5-month imprisonment sentence and a fine of Rs 10 lakh until further notice. The court's decision came after Patkar appealed her conviction and sentence handed down by a Metropolitan Magistrate Court last month. Patkar's appeal and application for bail under Section 431 of the Bharatiya Nagarik Suraksha Sanhita 2023 were both granted. The court has sought a response from Saxena and scheduled further arguments for September 4. The defamation case dates back to November 25, 2000, when Patkar, in a press note titled True Face of Patriot, accused Saxena of being involved in Hawala transactions, calling him a coward and not a patriot. Saxena, who was then the chief of the Ahmedabad-based NGO National Council for Civil Liberties, filed a complaint in 2001. The case was transferred to a Chief Metropolitan Magistrate Court in Delhi in 2003 by the Supreme Court. In 2011, Patkar pleaded not guilty, leading to a trial. The court convicted Patkar on May 24th, stating that her actions were deliberate and malicious, aimed at damaging Saxena's reputation. Patkar's statements were found defamatory and designed to incite negative perceptions without any substantial evidence to back her claims. The judge concluded that her remarks directly attacked Saxena's characters and loyalty to the nation. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire LiveLaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. So here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelawmedia.in for our in-depth reports and analysis. Not only this, but the LiveLaw channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I'm your host, Ostika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to LiveLaw. Thank you for watching.